School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 2 Business Forms and Legislations. Unit 3 The Partnership Act 1932. Part 1.
After completing this unit, you should be able to define partnership and explain its essential features, describe different types of partners and partnerships, differentiate between partnership and other forms of organization, discuss how registration of a partnership firm can be done, explain the circumstances when a partnership is reconstituted and a firm is dissolved, and appreciate the meaning of the term Limited Liability Partnership or LLP, its need, scope, advantages, and incorporation of LLP. Introduction. The development of business and growth in business transactions lead to the replacement of the proprietary form of organizations with partnership enterprises. Partnership is a form of business organization where two or more persons come together for jointly carrying on some business. In partnership, two or more persons pool their resources, both money and material, to their mutual advantage and thus share the business risk. Towards the end of 19th century, it was considered absolutely crucial to regulate the partnership form of business so as to control the evils, that is, many evils which crept in over passage of time, from spreading and contaminating the business organization and mercantile transactions. Initially, the Indian Contract Act 1872 governed all aspects of commerce and trade, and Chapter 9, Sections 239 to 266 of the Act regulated the partnership business. But these provisions were not exhaustive. Many aspects remained unnoticed and unregulated. This led to a need for more specific governance, and the government took steps to legislate further. Chapter 9, Sections 239 to 266 are replaced by Indian Partnership Act 1932. It is based on the English Partnership Act 1890. Partnership is a mere voluntary collective and has no force of law to its constitution. Thus, the concept of partnership is that a firm is not an entity or a person in law, but is merely an association of persons, and the firm name is only a collective name for individuals who have agreed to carry on business in partnership. A partnership arises from a contract, and therefore such a contract is governed not only by the provisions of the Partnership Act in that regard, but also by the general law of contract in such matters where the Partnership Act does not specifically make any provision. Thus, the rules relating to offer and acceptance, consideration, free consent, legality of object, etc., as contained in the Indian Contract Act are applicable to a contract of partnership also. Nature of partnership. Definition of partnership, partners, firm and firm's name. Section 4, the Indian Partnership Act 1932 lays down the definition of partnership, partner, firm and firm name. Partnership is the relationship between persons who have agreed to share the profits of the business carried on by all or any of them acting for all. There are three aspects to partnership, that is, partners, firm, and the firm name. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which the business is carried on is called the firm's name. Thus, a firm in law is only a collective name of the partners of a partnership. It doesn't have a separate legal existence as in case of a corporation. While acquiring the firm name, the partners should keep in mind that they do not violate the rules relating to trade name or goodwill. The adopted name must not mislead the public to confuse them with a firm of repute already in existence with a similar name. They must not use a name implying the sanction of patronage of the government. A partnership firm cannot use the word limited as a part of its name. Essentials of a partnership. The examination of the definition of partnership given in Section 4 of the Act indicates that there are certain elements which must coexist before a partnership can come into existence. They are: number 1, there must be minimum 2 persons. Number 2, the relationship must arise out of an agreement between 2 or more persons to carry on a business. Number 3, the agreement must be to share the profits of a business. Number 4, the business must be carried on by all or any of them acting for all. And number 5, each partner is liable for all the acts of a firm done by a partner. We shall now discuss all these elements briefly. Number 1, association of 2 or more persons. In order to form partnership, there must be a contract between 2 or more persons coming together for a common goal. Persons must be competent to enter into a contract. They may all be natural or artificial, or some natural and other artificial. There are at least 2 persons required, otherwise it cannot be a partnership. If this number gets reduced to 1 for reason like death or insolvency, the partnership ceases to exist. The Act is silent on the maximum number of partners, but Section 464 of the Companies Act 2013 has now put a limit of 50 partners in any association or partnership firm. The Companies Act 2013 lays limit on the number of partners in a partnership as follows. So here comes the number 1, and that is, the central government has prescribed maximum number of partners in a firm to be 50, YD Rule 10 of the Companies Miscellaneous Rules 2014. And secondly, Section 464(1) of the Companies Act 2013 states, and I quote, provided that the number of persons which may be prescribed under this subsection shall not exceed 100, unquote. Thus, the ceiling under rules can be varied, but under no circumstance can go beyond 100. Number 2, agreement. According to Section 5, the relation of partnership arises from contract and not from status. Thus, the members of a Hindu undivided family carrying on a family business or a Burmese Buddhist husband and wife carrying on business are not partners in such business. The agreement is the basis of relationship between the partners. The agreement can be in written or oral form, but it is preferred that the partners have a written agreement so that in case of dispute, there is a greater clarity as to their relation and position. Number 3, business. The agreement should be to carry on some lawful business. The term business includes trade, occupation, and profession according to Section 2, Clause B of the Act. In the definition of partnership, the word business means carrying on business, that is, continuity or repetition of acts. But that doesn't mean it should be lengthy operations. Even a single venture of an undertaking, if there is continued participation of 2 or more persons for acquisition of gains, is considered. Number 4, sharing of profit. To constitute a partnership, the parties must have agreed to carry on a business, not a charitable activity, and to share profits in common. Unless otherwise agreed, sharing of profits also involves sharing of losses as well. However, the sharing of profit is an essential element of partnership. The sharing of losses is not. The partners can agree to share the profits in any ratio and either in specific proportions or in specific sums. But if only one partner is entitled to whole of the profit, then there will be no partnership. Number 5. Mutual agency. The business of a partnership concern may be carried on by all the partners or any of them acting for all. This statement has two important implications. First, every partner is entitled to participate in the conduct of the affairs of its business. Second, that there exists a relationship of mutual agency between all the partners. Each partner carrying on the business is the principal as well as the agent for all the other partners. He can bind other partners by his acts and also is bound by the acts of other partners with regard to business of the firm. And number 6, liability of partners. Each partner is liable jointly and severally to the third party for all the acts of the firm done while he is a partner. The liability of a partner for acts of the firm is unlimited, that is, the partner's private assets can also be used for paying off the firm's debts. Types of partners. There are basically two categories of partners. Number 1, partners by virtue of partnership agreement, and number 2, partners by virtue of holding out as per section 28. The Act does not provide about the types of partners. This is decided on the partnership contract. In practice, based on the extent of liability, the different classes of partners are: number 1, actual, active or ostensible partner. Such a partner actively participates in the functioning and management of the business and shares its profits or losses. He acts as an agent of other partners for all acts done in the ordinary course of business. In the event of his retirement, he must give a public notice in order to absolve himself of liabilities for acts of other partners done after his retirement. Number 2, sleeping or dormant partners. These partners invest money in the firm's business and share profits but do not participate in the functioning and management of the business. However, they are liable to the third parties for all the acts of the firm. Such a partner can retire from the firm without giving any public notice to this effect. His liability for the acts of the firm ceases soon after retirement. Such partner has no duties to perform but is entitled to have access to books and accounts of the firm, and he can have a copy of them. Number 3, nominal partner. Such a partner neither invests nor participates in the management of the firm, but only gives his name to the business or firm. However, such partners are liable to third parties for all the acts of the firm. Unlike a sleeping partner, they are known to the outsiders as partners in the firm. They require to give public notice at the time of being separated from the firm. Number 4, partners in profit only. A partner who is entitled to share in the profits of a partnership firm without being liable to share the losses is called a partner in profits only. Thus, a person who has sufficient capital but is not prepared to take risk may be admitted to the partnership by the other partners. In spite of his specific position, he continues to be liable to the third parties for all acts of the firm, just like other partners. Number 5, sub-partner. Where a partner agrees to share his profits in the firm with a third person, that third person is called a sub-partner. A sub-partner is not the partner in firm. He is partner of a partner. A sub-partner has no rights or duties towards the firm and does not carry any liability for the debts of the firm. He can neither participate in partnership business nor check the accounts of such partner and claimed share. Also, he cannot bind the firm or other partners by his acts. The only right he has is to share the profits in property at the time of winding up. And number 6, partner by estoppel or by holding out. If a person by his act or words give another person reason to believe that he is a partner in a firm when actually he is not, and that other person takes action on those set of facts, such a person is stopped from later on denying the liabilities for the acts of the firm. Thus, it is a legally binding partnership that may occur where previously no formal partnership agreement was in place. Such person is called partner by estoppel and is liable to all third parties. Similarly, when the firm declares a person to be a partner when actually he is not, and that person knowingly permits himself to be represented to be a partner in a firm or does not deny the fact that he is a partner, then such a person is known as partner by holding out. An active partner who fails to give public notice at the time of retirement is also liable as partner by holding out. Position of minor as a partner. Minor admitted to the benefits of partnership. Since partnership is a contractual relationship, the parties to contract must be competent to contract under the law to which they are subject. A minor is incompetent to contract. Hence, he cannot become a partner, but with the consent of all the partners, he may be admitted to the benefits of partnership. Rights of minor. He is entitled to share of the property and of the profits of the firm as agreed upon. He can have access to and inspect and copy any of the accounts of the firm, but not any other book as per section 30 clause 2. A minor can sue the partners for an account or payment of his share of the property or profits of the firm when severing his connection with the firm. The amount of his share shall be determined by a valuation made as far as possible in accordance with the rules contained in section 48. Liabilities of minor. A minor is liable to the extent of his share in the firm. He is neither personally liable nor is his private estate liable for the acts of the firm. He cannot be declared insolvent if the firm's debts cannot be paid out of the firm's property. Position on attaining majority. A minor has a choice to become a partner or sever his connection from the firm within 6 months of his attaining the age of majority or when he comes to know of his being admitted to the benefit of partnership, whichever date is later. He has to give a public notice if he intends to become or that he has elected not to become a partner in the firm within 6 months. If he fails to give such notice, he shall become a partner in the firm on the expiry of the said 6 months as per section 30 clause 5. As per this section, such person becomes a partner where number 1, his right and liabilities as a minor continue up to the date on which he becomes a partner. Number 2, he also becomes personally liable to third parties for all the acts of the firm done since he was admitted to the benefits of partnership. And number 3, his share in the property and profits of firm shall be the share to which he was entitled as a minor. Where such person elects not to become a partner, number 1, his rights and liabilities shall continue to be those of a minor under this section up to the date on which he gives public notice. Number 2, his share shall not be liable for any acts of the firm done after the date of the notice. And number 3, he shall be entitled to sue the partners for his share of the property and profits. Types of partnerships. A partnership may be for a particular adventure or for a fixed period or at will. From the duration point of view, a partnership may be classified into 2 categories. Number 1, partnership at will as per section 7 and particular partnership as per Section 8. Number 1. Partnership at will. According to Section 7 of the Act, partnership is at will when Number 1. No fixed period has been agreed upon for the duration of partnership, and Number 2. There is no provision made as to the determination of partnership in any other way. The death or retirement of a partner does not affect the existence of such partnership, as there is no fixed or definite date of termination. Such a partnership can be dissolved by any partner giving notice in writing to all the other partners of his intention to dissolve the firm as per Section 43, Clause 1. The firm is dissolved from the date mentioned in the notice as the date of dissolution, or if no such date is mentioned, as from the date of communication of the notice. Number 2. Particular partnership. When a partnership is formed for a particular adventure or undertaking or for a particular period, such a partnership is called particular partnership. Such partnership automatically comes to an end on completion of venture or on expiry of the period. If partners want to dissolve the partnership before fixed period, it can be done by mutual consent, and if the partnership is continued after the expiry of the term or completion of venture, it is deemed to be partnership at will. Partnership distinguished from other forms of organization. Number 1. Co-ownership and partnership. If two or more persons own a property jointly and employ the same property in a business and share the profits, it is co-ownership and not partnership. The main point of distinction between the two is Number 1. Partnership always arises out of a contract, express or implied, whereas co-ownership may arise from an agreement or by the operation of law or from the status or any other way. For example, co-heirs of a property. Number 2. A partner is the agent of the other partners, but a co-owner is not the agent of the other co-owners. Number 3. Partnership involves sharing of profits and losses, whereas co-ownership does not necessarily do so. Number 4. A partner cannot transfer his rights and interests to anyone without the consent of all other partners. However, a co-owner can do so without the consent of the others. Number 5. A partner can only ask for share of the profits out of the properties, whereas a co-owner can ask for division of property. And number 6. A partner has a lien on the firm property, whereas co-owner does not. Next comes Hindu joint family firm and partnership. A Hindu joint family firm differs from a partnership in many ways. They are: Number 1. A partnership arises out of contract and a Hindu joint family or HUF firm out of status, that is, by birth in the family. Number 2. Partnership is governed by Indian Partnership Act and HUF by Hindu law. Number 3. A minor cannot be a partner, although he may be admitted to the benefits of partnership, whereas in HUF, a minor is a member from the very day of his birth by the virtue of his status, but he is not personally liable. Number 4. The death of a partner dissolves the partnership, but the death of a co-partner does not. Number 5. In partnership, each partner has implied authority to borrow and bind other partner, but in HUF firm, only the karta or manager, who is the head of the family, is entitled to do so. Number 6. Every partner is personally liable for the debts of the firm, but in a HUF business, only the karta is personally liable. Number 7. A partner can demand the accounts of the firm. A co-partner cannot ask for accounts. His only remedy is to ask for partition of the assets of the family firm. Number 8. Partnership firm must be registered before it can maintain suits against outsiders, whereas for HUF, no registration is necessary. Number 9. Every partner has a definite share and it can be changed only by agreement, but the share of a co-partner enlarges or reduces depending on the death or birth in the family. And number 10. There is a definite limit to the number of partners, but there is no such limit in the case of a Hindu joint family firm.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.